Thank you so much for staying with us on the show this morning. Sunrise. A federal high court in Abuja recently ruled that the 6-month suspension of Senator Natasha was excessive and unconstitutional, ordering the Senate to recall her immediately and declaring that such a lengthy ban would without clear legal basis, effectively denied her constituents representation. However, the same court also found Natasha in contempt of court, Senator Natasha in contempt of court, ordering her to apologize publicly and pay a fine for violating a gag order. Meanwhile, the Senate has responded by setting conditions for her reinstatement, which, of course, predicates that the Senate will only reconvene on the matter after she complies with the court's order. So where do we stand? Is this a landmark affirmation of constitutional limits on legislative discipline, or a political game wrapped in legal action? What does this mean for Nigeria's democracy generally? Two gentlemen join us to have this conversation this morning. Ajaja is a legal practitioner who joins us from our studio in Abuja. Thanks for joining us this morning.
Good morning. Thank you for having me.
Yeah, we also have a senior advocate of Nigeria in the person of Mr. Monday Ubani, also join us virtually. Thank you for joining us this morning, sir.
Yeah, thank you for having me. Good morning.
Yeah. Mr. Aja, let me start with you. How is Senator Akpoti-Uduaghan's camp receiving this balance of victory?
Well, the distinguished senator is in very good spirits. It's a victory for both her and for the institution of democracy in Nigeria, because the judgment yesterday is a reaffirmation of what we know. I'm not sure that any of the parties were surprised by what happened yesterday, not even the legal counsels to the defendants, because there's been a long line of judicial precedents affirming that Parliament does not have a right to suspend a parliamentarian indefinitely or beyond 14 days as provided by the rules of, especially the Senate this time around. So the distinguished senator and her able supporters and her very, very competent supporters are in very good spirits. They are in high spirits, and they are looking forward to the next stage, which is for her to resume her seat in the Senate to continue with her representation of the good people of Kogi Central.
Well, that is, but then you've spoken to one aspect of the judgment and not to the other, which is the two other conditions that the court has ruled. On the one hand, a 5 million naira fine; on the other hand, a full-page advert or advertisement in two daily newspapers.
Well, those are things that can be taken care of even within a single day. But then I must also say that what we had yesterday was the basic outlines of the judgment. We didn't have the comprehensive judgment. The judge promised to make that available within the next week, and then we'll go through the document. We'll still be within the 7 days window within which to make the public apology. We'll go through the judgment and then advise the distinguished senator as appropriate. However, let me say that the court was very emphatic that the contempt is to the court and not to the defendant, not to the Senate, so we don't conflate the issues. The contempt was in respect of an order made by the court restraining all parties from making media comments about the ongoing issues in the court, and whether in the public, whether in the conventional media or in the social media. And then in the wisdom of the court, the distinguished senator, the plaintiff in the matter, flouted or breached that order, and then even though we made an argument that it was not in respect of what was before the court, it was in respect of the allegation of sexual impropriety against the Senate president, but then the court in its wisdom ruled that there was sufficient connection between the post made by the distinguished senator and what was ongoing in the court, and then made the order it considered appropriate. So we look at it. We are still within time. By next week, when we have the fine print of the judgment, we will be in a better position to advise the distinguished senator.
All right, thank you, Mr. Aja. Mr. Ubani, you've listened to all sides, and it's something that I know that you've been, doing your best to intervene in the matter for a bit. So where does this put the, what's your position on this? Mr. Bani, that's for you.
Thank you for having me once again. You know what happened on yesterday was that the judge read her handwritten judgment, which has not been obtained. And so for a very comprehensive analysis of what actually happened yesterday, I will advise all parties to ensure that we get a copy of that particular judgment and look at it, in a very comprehensive manner in order to understand actually what was ruled by the judge. But from the counsels who were in court, the little I was able to gather was that, one, that the judge agreed that the Senate has a right to discipline any of their members, and that in this particular instance, they were right to have actually referred her unparliamentary misbehavior to a committee that was in charge of that. That was affirmed by the court. So the issue of disciplinary powers of the Senate was acknowledged by that ruling based upon what I was told. The second issue was the time she was reallocated to another seat, and she wanted to speak from a different seat entirely, and she was denied audience, which was one of the issues she raised in her reliefs. The court also found out that the Senate president was right to have denied her the audience because she was not sitting in the proper seat allocated to her. That again was affirmed in that particular judgment, I am told. Then the issue of contempt, while the matter was sub judice, the court also affirmed the fact that she was really guilty of civil contempt, and then asked her to pay 5 million naira penalty, and asked her to make publication in 2 national newspapers, and to apologize to the Senate leadership, and also to apologize to the court in her Facebook, where she posted that particular write-up and then pulled down what was already there and apologized in her Facebook page. That again was part of the judgment yesterday. The only pronouncement that was not too clear, and that was the pronouncement on the issue of the 6 months suspension. I heard that the court was saying, yes, even though you have a right to discipline a member of the Senate, that she considered that the 6 months suspension was excessive, and that we deny the members of the constituent adequate and effective representation, and that she is asking the Senate to consider recalling her back. That again looks as if, was it a substantive order? Because I'm reading people saying the court ordered the Senate to take her back. But the issue was that she was saying that she considered that as an opinion excessive, and then I asked the Senate to consider recalling her back. Now, why I'm worried about that pronouncement is because in the originating summons, the issue of suspension was never a relief sought by the lawyers to the plaintiff. What they were actually seeking for was the initial invitation for her to appear before the panel, and that they were saying that that was clearly a violation of her constitutional right. Now, the court has now affirmed that the Senate has a right to invite her, that the Senate has a right to discipline her, that the Senate has a right to deny her audience when she has not complied with the standing rules of the Senate. But the issue of pronouncement of the 6 months was not part of the relief, and they're making pronouncements. So we want to now find out whether that was an obiter dicta, made by the court, or whether it was a ratio decidendi, meaning a binding order. And that can only be, done by the time we have access to the judgment, either on Monday or Tuesday. Then we can now know what actually was decided by the court. For now, whatever we are doing is just probably, talking in peripheral, in a peripheral manner, what was actually decided, not the real, fact of what was decided by the court, because we don't have access to the judgment of the court. So we have applied for the certified true copy of that judgment in order to have a clear understanding of what the judgment was concerning the 6 months suspension that the court made a pronouncement of.
Well, thank you, Mr. Rani. But, Mr. Ajab, there are those who are watching now wondering whether this is all politics or it does truly have the full trappings of of legality at play. On the one hand are the issues of the rules of the Senate. On the other hand, of course, there are allegations here and there. And with all of the, first of all, I don't know if you agree with all of the comments that you heard from Mr. Ubani, but to which extent you can also speak to it. So there's the place of the rules, there's the place of, you know, personal issues and all of those things. It would seem like politics is at the center of it all. Or is there more to it, in your opinion, Mr. Aja?
Well, wherever politicians are, there must be politics played. That is to take it away from the court. But let me address part of what Leonard Sirk said. There was no order on the plaintiff, on distinguished Senator Natasha, to apologize to the Senate. None whatsoever. In fact, the court was very, very explicit that this contempt is to the court, that it was the court that made the order gagging the parties, and so whatever breach occurred against the order of the court. Therefore, the apology must be made to the court. The judge had to even pause when she was, because I was in court yesterday, had to pause to adumbrate on that, to say that she will apologize to me, because if it were to be criminal contempt, well, I would have sent her to a correctional center for custody. But since it is a civil contempt, then she's going to pay such amount of money to the coffers of the Federation, and as well as apologize to the court whose orders she breached. That is that. Then let me also address the issue of course, we know that the judgment is what is read in court. What we'll be having is the paperwork, so to speak. The judgment, that's provision of the law, that the judgment must be read in open court before parties, before so on and so forth. That's one of the qualities of a good judgment. Then, what the judge said in respect of the 6 months, of course, the judge acknowledged that Parliament has the power to discipline its members, flowing from both the Constitution, which granted them powers to make rules regulating their procedure, as well as to the Legislative House's Powers and Privileges Act. But then, the judge said that it was not, the powers were not at large, so to speak. They were circumscribed. And the judge, like I said before, the judge was bound by stare decisis, and there are judgments preceding hers, including to the Court of Appeal, which is the Superior Court, saying that any suspension of a parliamentarian must not exceed 14 days, pursuant to their chapter 9, rule 67 or the 4 or thereabout, if I'm not mistaken. Even though they wanted to make an argument that they were going pursuant to Order 8, but the courts, the precedents we have, the stare decisis we have, is to the fact that it must not exceed 14 days. In fact, the judge was very emphatic that suspending her for 6 months was already in excess of half the year, because the Parliament is obligated to sit for not less than 180 days. But then 6 months is more than half the year. So the judge was of the view that the victims here are the people of Kogi.
Well, I also know that you okay, go ahead, land on your thoughts. Land on your thoughts, because I didn't stop you initially.
Hello,
Go ahead, can you hear me now? Can you hear me now, Mr. Aja?
Yes, I can hear you now.
Okay, go ahead and land on your thoughts.
So the judge was very emphatic that the victims in this instance was not even Natasha, so to speak, but the people to whom she owes her duty to speak up, to representation. And therefore, she said that it would be so improper, it would be so inappropriate. In fact, it could never have been the intention of the makers, of the framers of the law, whether the Constitution or the Legislative Powers and Privileges Act, to keep a lawmaker away from the lawmaking body for 6 months. In fact, she said that if it is in excess of 14 days, it's excessive. And therefore, having heard that the suspension was illegal to the extent that it exceeded 14 days, she made a consequential order, saying that she therefore recommends that the Senate recalls her. And I had one of the learned Sikhs that represented one of the defendants.
Just a second, Mr. Aja.
And I don't seem to agree.
Just a second. Okay. You just said now, you said that the judge says she recommended that the Senate should reconsider.
Should recall her.
Recommendation.
Not reconsider, recall her.
Is that an order? Is a recommendation an order?
Let me put it clear.
Okay.
A court of law is not the same thing as a judicial panel of inquiry, which makes recommendations to a third party, probably the executive branch of government. But the recommendation, if you look at section 318 of the Constitution, which provides what it includes judgment, it includes orders, it includes convictions, sentences, and recommendations. In other words, there is basically no difference between 6 and half a dozen. So a recommendation is a positive order of court, and it is not subject to the discretion of the person to whom it is addressed. Once a court recommends that you take a step, it is deemed that the court is ordering you to take that step.
Okay.
That's my view of it.
Okay.
Because
and I know that
captured in the Constitution that recommendation is one of the decisions a court can give, and it's not subject to a third-party interpretation.
Okay, and I know that the learned seal,
the intention of the makers of the Constitution.
I know that the learned seal could want to speak to that as well, but there is also something that you may want to also confirm or refute. The fact that the judge, the same judge, says that the Senate was right, or the president of the Senate, who was the chairman of that assembly at the time, was right to not take the opinion of the senator, of Senator Natasha because she was not sitting in the place where she was supposed to sit. Is that also correct? You want to speak to that?
Yes. Our argument is to the effect that point of order on bordering on privilege should take preeminence, should take priority over even the sitting arrangement. But the learned judge seems to disagree with that, saying that even though she had a right to raise a point of order, but she could only raise it from the point assigned, from the seat assigned to her in chambers. So that's the ruling of the court. Of course, that's what the judgment said.
Yes,
the ratio?
Yeah.
We see the reason behind it in the written document. Then.
But isn't that, Mr. Aja, sorry.
For the pronouncement of the court yesterday, yes.
Yeah.
The judge said that the right to ventilate any grievance you may have as a result of a point of privilege can only be taken when you are on your seat.
But isn't that the fulcrum of this whole brouhaha in the first place?
Sorry, is it addressed to... Okay.
Yes, that's for you. Isn't that the reason for this whole, legal back and forth in the first place?
Well, it may be. It may not be. And I say so because it is the person that wears the shoe that should... Fine. Based on the judgment right now, we may say that, fine, she may have a legitimate need, a legitimate cause to complain as to why she was moved from one position to the other. But then the court is of the view that she could have better ventilated that view from a seat where she was assigned. Probably the court, the Senate might have considered it. That's the view of the judge. That's the position of the court. But then, as I said, and as the senior advocate also said, until we see the judgment, because the judgment is not just the pronouncement, but in fact, the main thing about the judgment is the reason behind it. Not the pronouncement you hear that this person is guilty or not guilty, but the reason for the pronouncement. So until we see the reason for the pronouncement in the certified copy of the judgment or in the enrolled order, before we can appropriately address this issue. But as for now, that is what the court pronounced. All
right, well, Mr. Bani, the issue that I reserved for you to respond to is part of what Mr. Aja said earlier about the recommendation of the judge. Is recommendation an order? Because in my English grammar, it sounds like it's something you may or may not take. Like the former president said, well, it's your job to give me an advice. It's my job to whether take it or not.
Yeah, thank you, Ayo. Once again, I want to say that I was not present in court. I'm presently in Enugu for the public hearing of the constitutional amendment that is actually going on all over the 6 geopolitical zone in the country. So I wasn't present, but I sent, representatives, and then our counsel, the person of Paul Dowd, who was also the son, was in court. What he said, what he reported to me was that it was the court's acknowledgement of the fact that he says that the Senate has the right actually to discipline any of their members. And that the only thing that she frowns out was the issue of 6 months, as she considered it to be excessive. and she's asking that the Senate should consider. When you use the words consider, that's why I'm saying that it is important we have a copy of the judgment to consider recalling Senator Natasha back in the light of the fact that 6 months was too excessive, as that actually we deny effective representation to the constituents, she's represented. That is what I heard that was said. But let me say this. There is no way a court can give you what you do not ask for. You will be the one to ask for certain things before the court grants you. It's not a Father Christmas. In the originating summon was dealing with the invitation that was extended to her to appear before the Committee on Ethics. And that was what she was challenging. There was no other originating summon that actually dealt with the issue of suspension, because in the course of that originating summon against invitation, she was eventually suspended. And she did not file, the lawyers did not file any further originating summon challenging suspension. Only they came by way of an application. An application, you cannot initiate a process through an application. Maybe a mandatory injunction or any injunction whatsoever. You don't initiate a case, through that process. You come by way of originating process, which is either a statement of claim or summons, originating summons. Now, for the court to make a pronouncement on that suspension, there must be a relief sought to nullify that suspension in an originating process. And I'm saying, that's why some of us are thinking that it could be that the court was just making an obiter, by saying, look, in my opinion, I think that 6 months suspension was excessive. And I'm only recommending that the Senate should reconsider, calling her back so not to deny representation to her constituent. That we consider to be an opinion and not a judgment and not an order of the court. But it's also important that we get a copy of what the judge, the learned judge herself, has made as an order of the court, so that we can begin to really appreciate, what has happened. From my own perspective, the little I know about this case is that there was any originating process that challenged suspension. What she and her lawyers were challenging was an invitation to the Ethics Committee to appear in order to look at her conduct before the plenary of the House. So that is what she went to court for. But if the court now is making a pronouncement on suspension, we now want to know where that was derived from. Was there any other process filed challenging the suspension? In which case now the court has the right now to say, oh, it's either illegal or it's excessive and all that. In that circumstance, if there is not, then will we consider that to be an obiter or something that was said, just in passing, and that does not in any way become an order of the court. So having the order, the certified true copy of that judgment, we clear all this down. And so we now be in a position whether to comply or not to comply. And now I'm saying that it's important we have a copy of that really, even for the plaintiff herself, who is now threatening that she's going to resume on Tuesday. What is the basis of resuming on Tuesday? Have you gotten a copy of the judgment? Have you complied even with the order of the court before talking about resumption on Tuesday? So it's important that these things are sorted out. Having that copy is very important for both the defendant and both for the plaintiff.
Well, great. We also listened.
May I just say a word?
Okay, go ahead.
Just say a word here. Yeah, probably the learned Sikh is not privy to the final documents filed, because the really 14 and 15 in the amended originating process clearly talks about the court, asks the court. In fact, if I may read it, if you don't mind, just a minute, I may read what it has. An order, the plaintiff seeks an order of mandatory injunction setting aside all the resolutions of the second defendant pertaining to the plaintiff passed during plenary session on the 6th day of March 2025, which ratified the report of the fourth defendant's committee dated March 2025, purporting to suspend the plaintiff from the Senate of the Federal Republic of Nigeria for a duration of 6 months. So is there one of the prayers of the plaintiff, of the distinguished Senator Natasha?
Okay.
And let me also say that part of the relief sought by the plaintiff, which was actually not pronounced upon by the judge, was that the plaintiff was in breach of a subsisting order of court, restraining them from going ahead with any disciplinary procedure. When they now went ahead to set up a committee to now that suggested that recommended her suspension, The court did not pronounce on that. But in respect of the view of the learned Sikh, Ubani, with due respect, that there was nothing in the plaintiff's processes that relates to suspension. No, really 14 and 15 in the amended originating summons actually speak to the issue of suspension. Okay. And I think it is on that basis that the court made the pronouncement on recalling her.
Okay. Well, Mr. Ubani, let me thank you very much for that, Mr. Aja. Well, to the issue, very quickly, Mr. Ubani, you said you are in Enugu for this constitutional amendment thing, and I'd like you to quickly answer a question on that. At the very least, the Constitution of the Federal Republic of Nigeria has been amended 16 times since 1999. And that is a staggering number. Doesn't that in a way validate the call by a good number of people that we need a totally new constitution? Otherwise, every time we have this constitutional amendment process, we spend money in at least 100 billion per time.
Yeah. That is a very valid point in probably having a new constitution made by the people themselves, because we have accused the 1999 constitution as being a military constitution. But over time, Ayo, if you follow the process, there is always room for input of the people in the constitutional amendment process. But the only problem is the institutions that have been set up in order to give final approval before the constitution become operational. I mean, I'm talking about amendment. You know, it passes through the National Assembly first. Then it goes to the various states House of Assembly all over the Federation, where you have to gather to third majority before you can amend. And then the constitution now comes back again to the National Assembly, who now, pass it as a law and then send to the president for assent. Most times we have had issue that it's either it dies, the recommendation for an amendment dies at the National Assembly, or it dies at the state level, or when it has even gone through all that process and comes to this National Assembly now for the president to assent. We now amendment over time, in order bit of reflection of the people's input. But over time, those institutions that have been set up along the line in order to give final approval have always been a stumbling block. And that's why this 10th Assembly said, look, let's get all the stakeholders involved, even in the initiating process. When we are doing this particular amendment, we say, look, the Attorney General's office must be involved. We must get the governors also to be involved. We must get the speakers of the various State House of Assembly to be involved. By the time all of us agree that this is what we need to change, we won't have any of those institutions now being a stumbling block when it comes to final approval. And that's why this one has virtually all the input of stakeholders. We have gotten the states as speakers. We have gotten the ministry of their knowledge of what is being imputed in this amendment process, believing that when we go through that one, we won't have a situation.
Oh, well, Mr. Ubani, we definitely need to have this conversation all together again. Yeah, my apologies.
Because almost 59 items we are listed.
Well, my apologies, Mr. Ubani. The network was going back and forth, but we definitely need to have this conversation when you are back in town so that people can understand the basis for this and why we have to go through this routine all the time.
Are you hearing me now?
No, don't worry. We're out of time. We're out of time, Mr. Ubani.
Yes, are you hearing me now, sir?
I can hear you now, but we're out of time. But we'll definitely have to have this conversation when you return to civilization. If I can't put it that time, forgive me. Thank you so much for your time this morning. Mr. Monday Ubani is a senior advocate of Nigeria, joined us virtually from Enugu. We've also had Mr. Ajaja, who is a legal practitioner. Gentlemen, thank you so much for your time this morning.
My pleasure. Thank you.
Okay. So we take a short break and we return with another discussion. To stay with us.